Hello, everybody, and welcome. This is InjuryDoctorHelp.com, and I have on the phone today on this video a special guest, Dr. Tim Redenbaugh. Say hello, Dr. Redenbaugh.
Hello, everybody.
And what we are talking about today is why attorneys really should have a good understanding of ICD-9 codes. Now, Dr. Redenbaugh, whereabouts do you practice?
I practice in Storm Lake, Iowa.
All right, excellent. And how long have you practiced there?
I've been in this current location for 15 years.
Wonderful, wonderful. And I guess in those 15 years, how long have you been doing personal injury-related care work?
I've been doing personal injuries for about 12 years now.
Now, Dr. Redenbaugh, if you would, could you explain a little bit further what are ICD-9 codes and why are they important for attorneys to understand them and their proper use?
ICD-9 codes explain what the injury is to the human body. If you get injured in a car accident, your body goes through several stages. First stage, you have a contusion. Then you have a sprain. And if it's severe enough, you have ligament laxity. Each ICD-9 code has 5 to 7 numbers, and the insurance company assigns a value to each one.
And if an attorney is getting ICD-9 codes or getting a minimum number of ICD-9 codes in the paperwork from the providers of their client, what should they do?
When you bill the insurance company or set a letter of demand to the insurance company, the doctor's ICD-9 codes and the attorney's ICD-9 codes from the doctor should match. With the limited number of spaces on a HCFA, usually most doctors only put in 4 codes. And with the new electronic billing, they can put up to 6 or 8. But when I do a car accident code, I list all the car accident codes. Generally, it's a double-digit number. It could be as high as 35, or it could be as low as 18.
Dr. Redenbaugh, how are claim values calculated by insurance companies?
Insurance companies weight each thing pretty equal. The ICD-9 codes is 25% of the claim. The impairment is 25% of the claim. The duties under duress, which is the things they cannot do, and the loss of enjoyment, which is the last 25%, which is they have to hire somebody to help them do laundry or mow the grass. That's part of the claim.
If the provider does not have these particular ICD-9 codes or enough of them to properly document, what does the insurance company then do?
If the provider does not give enough of the codes, the provider gives approximately 30 codes of the value drivers, and the attorney gives the other 13. What will happen is the claim values will be reduced from the missing ones.
So I guess it will lower the value of the case then?
Yes, it'll bring the value of the case down.
Why do medical care providers commonly include only 4 or fewer diagnostic codes?
Generally, the insurance company receives this form from the doctor, and there's only spaces for 4. Some insurance companies will have you write additional codes on, but most providers do not know this. Or the other thing is you can send in supplemental codes or HCFA claims, which usually have to mark supplemental with no treatment on the bottom, so you get all the codes listed.
So if attorneys are receiving documentation from their providers and there's only 4 codes listed, that could mean that there's a minimum amount of injuries present, or that could mean that the provider doesn't know enough of the paperwork to properly file it and include all the diagnostic codes. And how does your office handle that?
When our office handles it, when we include the SOAP notes, we list all of the ICD-9 codes right into the software that we use. So each time the insurance company requests records from us, they get a full list of the software, and they also get all the ICD-9 codes in each SOAP note, so we do not miss any of it.
Why do medical providers and attorneys commonly miss loss of enjoyment and duties under duress?
The insurance companies have their own codes and standards. The rest of the medical field uses outcome assessments, but the insurance companies for the car accidents choose to use loss of enjoyment and duties under duress. So it's just knowing who you have to talk to. if you use outcome assessments, you got to talk to the normal medical community, but you need to use duties under duress and loss of enjoyment for the auto industry.
Understood. And now, is it important that the provider uses those particular phrases, duties under duress and loss of enjoyment?
In the auto insurance software for the processing claims and determined values, that's the exact wording you have to use. Otherwise, they don't have to use it. And you also reduce up to 50% of your claim by not using the proper language.
So by not using the proper language and using the proper codes, the claims adjuster won't put in the information adequately in order to properly value out the claim. Is that correct?
That is correct. Under the law, he does not have to add anything or take anything away if it's not in the correct form.
And now, is this correctable if an attorney has already sent in this paperwork and they're in the middle of maybe resubmitting the paperwork? Is it correctable in order to resubmit the paperwork with the additional coding and the proper wording?
Yes, the attorney can send in the proper codes and the proper wording at any time up till trial or when the patient settles. If they do that, the adjuster would have to run it back through the computer system, and he would get a new value.
Dr. Redenbaugh, if you would explain a little bit further, what is a broken case in regards to ICD-9 codes, and how can you help fix a broken case?
A broken case is when a medical doctor, a chiropractor, or a physical therapist fails to send in all the ICD-9 codes. What I would do is I would talk to the patient, go over their complete history with them, include all the proper ICD-9 codes, find out what duties under duress that they've had, the loss of enjoyment they had to incur, expenses, and I would put that all into one SOAP note. That way it can all be entered into the computer in a proper manner.
Now, if an attorney out there feels that they have a broken case and they want you to go ahead and take a look at it, what's the best thing for an attorney to do in order to make that happen?
The easiest thing is to call me and talk to me. If they're close, I can have them send the patients in, and we can sit down and run the patients through the software and get all the ICD-9 codes, make sure they have the impairments were corrected, make sure that the duties under duress and loss of enjoyment is all correct. If they're further away into the state, I can call and talk to the patient over the phone, and we can do the exact same thing over the phone.
All right, and your phone number is?
712-732-3349.
Thank you, Dr. Redenbaugh, and thank you for the attorneys out there who have watched this video. If you have any other questions, just reach out to Dr. Redenbaugh, and he can answer your questions further. And have a good day now. Thank you.